Hi, I'm RJ Baxter with Fairway Independent Mortgage with your daily video, and I'm here with Molly Zwerdlinger, who's an estate planning attorney. And what's the name of your firm, Molly?
I'm with Miller & Steyert. We're down in Littleton, Colorado, and I also do not only estate planning but probate as well.
Okay, awesome. And you're going to talk a little bit more with us today about types of home ownership when it comes to holding title on a house and how that affects things when in the event of your death or your spouse's death. Is that right?
Yes, it's an incredibly important topic for people to understand, and quite frankly, it's so important that my first day of law school was property class, and the first thing the professor brought up was this idea of tenants in common versus joint tenancy. And people assume that if you have two names on a deed, that it's automatically joint ownership, and that's actually not the case. So in order to have joint ownership and to have that the consequences that come with that, the deed itself by which you received the property has to say one of the following phrases: in joint tenancy, as joint tenants, or joint tenants with right of survivorship. If the deed does not say that magic language, it doesn't matter if it's your spouse on the deed or somebody else, it's not jointly owned. It's the default is if it's not joint, that it's tenants in common. And the consequence of that is if you die, if it's jointly held and we've got that magic language on the deed, then the property automatically transfers from one joint owner to the other. So that's the consequence at death, is that it's an automatic transfer. Without that magic language, whether you're married or not, you end up where you own individual ownership of the property. So say my husband and I own my property, or own our property, and it's not jointly owned, there's no joint language on the deed, then what ends up happening is if I die, I own 50% as a tenant in common individually. So the property is going to transfer potentially to someone else other than the joint owner.
So from my understanding, that if it's tenants in common, the 50% that the other spouse owns has to be settled in probate.
That is
to
correct.
Decide then who takes ownership of that half of the property.
That is exactly right. So if you own real estate in your name alone, which even if it's a 50% tenant in common interest, it will trigger probate and transfer to the person who inherits it, not necessarily the other owner.
Very interesting. So does it actually say tenants in common on the deed, or do you mean that if it doesn't have that joint tenancy language, it's automatically tenants in common?
It depends on the deed. So if there is no joint tenancy language and it's silent, it's automatically assumed. The default in Colorado is tenants in common, but some deeds do in fact say tenants in common.
Okay, interesting. Well, that's really good information to share, and we get that question a lot too on the lending side as far as how to hold title, or what the best way is to hold title when there's a married couple or more than one person.
And the reason why is the consequences at death can be huge.
For sure, for sure. So if you have more questions about that, if you want to look at your particular situation, Molly is an awesome resource, so just give her a call, let her know what your questions are, and she'd be happy to answer.
Thanks, RJ, appreciate it.
You're welcome. So thanks for joining us. Once again, my name is RJ Baxter with Fairway Independent Mortgage. This is Molly Zwerdlinger. You guys have a great rest of your day.